Okay, welcome everyone to Inverse Condemnation Water World. Brief introductory remarks. My name is Evan Walker. I'm a solo attorney here in La Jolla, which is in San Diego, California. I'm a plaintiff's guy, so I represent people with personal injuries. It's about 60% of my practice. The other 40% is what I like to call property damage cases. So that's where you have first party or third party property damage cases. Why is that important for you? Well, that's how I got into inverse condemnation, which is what we will be speaking about today. I came across it in the context of property damage cases because this is how it develops. If I have a property damage case and it's a third-party case, meaning it's the property owner against a negligent third party, not a first party like an insurance carrier, and that defendant is a public entity, anytime I'm faced with that scenario, the first thing I do when I look at this case, I say to myself, is this a case for inverse condemnation? All right? Now we'll get into it and you'll see why these types of cases crop up in what I describe as property damage cases. So a few introductory remarks here. Frankly, inverse condemnation is a nebulous area of the law. There's a lot of, I wouldn't say uncertainty, I would say confusion that comes about really once you start to dig in deep with the case law. Part of the problem, in my opinion, is that you're dealing with constitutional claims, but that also overlaps with tort claims, at least under the California Government Tort Claims Act. And that also gets into public entity immunity. And so you start very easily, you start to get, you can get overwhelmed and you can get confused when you start to look at inverse condemnation. Part of the problem too, which we'll hopefully make some headway in working through, is that some of the same concepts that any first-year law student will know from torts, proximate cause, reasonableness, are taken out of that context and used in the inverse condemnation context, which arguably, and at least traditionally, was limited to a strict liability analysis. So that's part of the problem. Part of the problem also is depending on what decade you're pulling your cases, you may think they stand for different things when other cases have come along and have refined that decision, but not explicitly so. And so what you can be left with is a host of kind of muddled thoughts when you're trying to work through this. So we're going to do our best to try to get some clarity on this issue. Something else to keep in mind is for the first time in over 20 years, the California Supreme Court has just handed down an inverse condemnation case, which is known as City of Oroville. We'll talk about that case. My position is that's going to be a very consequential case, and its ramifications are going to be felt for years, if not decades, to come. Now, getting on to the slides here. Focus is on inverse condemnation. Well, what does that mean? Well, this is California specific, all right? We're not speaking about other states. We're not speaking about federal law or the federal Constitution. We'll speak about the federal Constitution once, only to contrast it to the California Constitution. So something to keep in mind when you're thinking of inverse condemnation is, well, compare it to direct condemnation. Direct condemnation is where the government, through the power of eminent domain, pays just compensation for private property used for public use. In a direct condemnation case, this is what you have. It's going to be the government versus the property owner. Inverse condemnation is the exact opposite. That's where you're going to have the property owner versus the government. So the roles are switched. Getting back to the slides here, we're going to even narrow the focus even more. The focus is going to be on water in the context of inverse condemnation, hence water world. And so what that means is, and this is where also the case law gets confusing, you have to determine what type of water you're talking about, right? So there's stream water, surface water, and then everyone's favorite, flood water. So you always have to keep in mind the body of water that you have in your case. So what that means is we're not talking about landslide inverse condemnation cases. We're not talking about fire inverse condemnation cases, which we'll talk about at the end is currently a hot topic. We're just limiting this focus to inverse condemnation in water. And we're going to even restrict it a little bit further, where the narrow focus is on physical damage caused by water in the context of inverse condemnation. So what do I mean? I mean we're not talking about regulatory takings. Okay? There are really two classes of inverse condemnation. It's going to be takings, which 9 times out of 10 deal with regulatory takings, and then damage, and that's what we're talking about. So to take a step back, we're going to be speaking of property damage cases involving inverse condemnation where property was damaged as a result of water, whether that's stream water, whether that's flood water, whether that's surface water. That's going to be the focus on this case. So now that we've got that out of the way, what are the elements of inverse condemnation? Well, the case law is fairly clear about this. You need ownership, right? Then you need government substantial participation in the public project, all right? And we'll talk a lot about that. You also need taking or damaging of private property. Finally, you need causation. Now, a quick word about causation. We're not talking about negligence. However, wait till you see when we get to the city of Oroville and how there's an argument to be made that now we're getting very close to negligence concepts and away from strict liability. So, moving on to the second slide here. So this is a quote from Article 1, Section 19 of the California Constitution, which is where inverse condemnation comes from. It's important, actually, just to read this out loud so we can get our bearings. Private property may be taken or damaged for a public use, and only when just compensation, ascertained by a jury, unless waived, has first been paid to or into the court for the owner. All right. What's important about this? Well, if you look at the first part of it, it says private property may be taken or damaged. Well, compare that to the Fifth Amendment of the U.S. Constitution, which reads, and I quote, "Nor shall private property be taken for public use without just compensation." Well, what do you notice about that? Well, the Fifth Amendment for the U.S. Constitution doesn't have the word damaged. It has the word taken. The California Constitution has taken and damaged. So there's an argument that the California Constitution is broader in the context of inverse condemnation than the federal Constitution. And like I said a minute ago, 9 times out of 10 when you're dealing with regulatory takings, you're not dealing with physical damage at all. So it's important for our purposes, again, looking at water damage in the context of inverse condemnation, you focus on the damaged part of the clause of Article 1, Section 19 of the California Constitution. Well, what does that mean? Well, for California practitioners, it means you are outside the California Government Torts Claims Act, right? That's inapplicable. So the government immunity, the arguably onerous pre-filing requirements and time restrictions are simply inapplicable to an inverse condemnation cause of action. It's 100% outside that statutory framework.